Good morning, ladies and gentlemen, and welcome to this seminar on business interruption insurance and professional negligence for brokers in relation to that issue. My name is Grantham, Queen's Counsel, and I shall be addressing the recent test case on business interruption, and Aidan Reay will be speaking on professional negligence of insurance brokers in this area. So, technology permitting, I shall share my slides with you. I hope you can now see my slides. Well, I say good morning, ladies and gentlemen. One of the many issues that is likely to arise out of the current coronavirus pandemic is the extent to which an insured may be entitled to claim on its insurance policy in respect of the closure or disruption of its business. Business interruption cover is provided upon the occurrence of a specific insured event, and therefore the wording of each policy will be critical. So as this is a talk about coronavirus, I should give you a health warning. Any advice or indication I can give you as to the likely interpretation of insurance policies is very specific. You will not be able to advise your clients without giving very careful attention both to the judgment in detail and the terms of the policy upon which you're advising. But in general terms, often business interruption policies will provide an indemnity where financial losses are suffered by a business consequential upon material damage to property. Clearly, such policies won't provide an indemnity where businesses are affected solely by reason of the consequences of regulatory responses to the pandemic. However, certain policies do provide cover independently of any material damage to property, often by way of an extension to damage cover. Until recently, the leading case on business interruption cover independently of damage was the decision of a Hong Kong Court of Final Appeal in New World Harbourview Company Limited and Ace Insurance Limited, which still remains persuasive authority on the issues it decided. The issue in that case concerned the construction of two composite mercantile policies issued by the respondents, Ace Insurance. The appellants owned a number of convention centres, hotels, car parks, and other businesses. They made a claim on their policies, subsequently commenced proceedings to recover an indemnity in respect of losses sustained from interruption to their business caused by severe acute respiratory syndrome, or SARS, in 2003. Each of the policies contained a clause which provided that this policy is extended to ensure actual loss sustained by the insured resulting from a reduction in revenue and increase in the cost of working as a result of infectious or contagious disease occurring on the premises of the insured or of notifiable human infectious or contagious disease occurring in 25 miles of the premises. And that's a fairly typical disease type extension, as we'll see in a moment. Such clause therefore provided cover against loss of revenue and increase in cost of working as a result of the occurrence of disease upon the occurrence of two separate events. First, infectious or contagious disease on the insured premises, and secondly, notifiable human infectious or contagious disease occurring in 25 miles of the premises. Claim was brought under the second limb. Two issues for the final Court of Appeal were, first of all, whether in common form and widely issued policies of the type in question, the provision of insurance cover in respect of loss sustained as a result of notifiable human infectious or contagious disease is limited to cover losses resulting from infectious diseases which are by statute compulsorily notifiable, or whether such cover extends to losses caused by diseases subject to administrative reporting requirements, although not backed by statutory sanctions. That was the first issue. The second is, what is the commencement date of cover under clause 14.5 of the policies instead of any claim made as a result of SARS? On the first issue, the final Court of Appeal approached the issue of construction of a policy as it would any issue of contractual construction. And on that basis, it held that notifiable human infectious or contagious disease meant a disease that was required by law to be notified to an authority. On the second issue, the final Court of Appeal held that the commencement date of coverage was the date upon which the disease became notifiable as a matter of government ordinance. It followed that losses suffered by the appellants from SARS prior to that date was not covered. Prior to that date, the insured event hadn't occurred and the cover wasn't retrospective. As I said, that case remains persuasive authority, particularly on the second issue, where there is no authoritative guidance from the English courts. It was a case which was referred to the recent test case, and it is to that which I shall now turn and devote the rest of my talk. It's fair to say the test case is a lengthy and rather difficult case to read. It stretches to no fewer than 580 paragraphs. And when I say I hold up the authority, give you some idea, that's on double-sided copying. So the case dealt with, first of all, the history of the pandemic. Secondly, government measures and categories of business. Thirdly, policy coverage. Fourthly, causation. And fifthly, prevalence. The judgment was handed down on the 15th of September of 2020 by Lord Justice Flaux and Mr. Justice Butcher, and the case was formerly called Financial Conduct Authority and Arch Insurance Limited and others. Cases brought by the FCA as a test case to determine issues of principle in relation to policy coverage under various assessment policy wordings underwritten by the defendants that potentially provide an indemnity for BI losses arising in the context of the COVID-19 pandemic and legislative and administrative responses thereto. Numerous policies within each category were considered, and the only reliable base on which to advise your clients is a careful consideration of the lengthy judgment, which, as I said, runs to no fewer than 580 paragraphs. That said, it is hopefully possible to identify some general principles which may at least provide some assistance. And as I say, it dealt with those 5 issues which appear in the slide. So let me deal next with the key facts. So the first outbreak of the disease was on the 31st of January of 2020 in the United Kingdom. On the 5th of March, COVID was made a notifiable disease, and SARS-CoV-2 was made a causative agent in England by amendment to the Health Protection Notification Regulation 2010. On the 6th of March, the same was applied to Wales by amendment to the Health Protection Notification Wales Regulation 2010. On the 11th of March, the WHO, World Health Organization, declared COVID-10 to be a pandemic. 16th of March, the United Kingdom government provided guidance on social distancing for vulnerable people. And the first really key date, as far as we're concerned, was the 21st of March of 2020, in which the Health Protection Coronavirus Business Closure England regulations and equivalent regulations for Wales were made. This is an important date because this is the first date upon which the force of law was applied to closure of businesses. On the 23rd of March 2020, the Prime Minister announced that the population had to stay at home and the closure of all shops selling non-essential goods and other premises, including libraries and outdoor gyms. On the 25th of March of 2020, the Coronavirus Act itself was passed, and on the following day, the Health Protection Coronavirus Restrictions England Regulations 2020 were made, largely replacing the regulations made on the 21st of March, and similar regulations were made for Wales. These regulations have been amended on several occasions and are the key pieces of legislation to which we need to refer. I shall refer them moving onwards as the regulations. On the 4th of July 2020, the regulations were revoked prospectively and replaced with more limited restrictions by virtue of the Health Protection Coronavirus Restrictions Number 2 Regulation 2020. Within the judgment, And based on the regulation, a categorization of various types of business was adopted. First of all, category 1, these were businesses listed in Part 1 of Schedule 2 to the regulations, such as pubs, bars, cafes and restaurants. Those are businesses that were affected by Regulation 4.1 of the regulations. Category 2, these are businesses listed in Part 2 of Schedule 2 to the regulations, such as cinemas, theatres, nightclubs, indoor gyms, beauty salons, spas, and car showrooms. These are businesses affected by Regulation 4.4 of the regulations. Third category is businesses listed in Part 3 of Schedule 2 to the regulations, which I might term essential shops, such as food retailers, off-licenses, pharmacies, petrol stations, and car repair garages, excluded from the scope of Regulation 5.1 of the regulations. The fourth category was businesses offering goods for sale or hire in a shop or providing library services, often referred to as non-essential shops, because they were not listed in Part 3 of Schedule 2 to the regulations, but were affected by Regulation 5.1 of the regulations, which imposed restrictions. Category 5, these are businesses not referred to in the regulations at all, and they include professional service firms, as well as construction and manufacturing undertakings. Category 6, businesses providing holiday accommodation, which were affected by Regulation 5.3 of the regulations. And finally, Category 7, places of worship, which were affected by Regulation 5.5 of the regulation, together with nurseries and schools. In the next section of the judgment, the court proceeded to address well-known and familiar general principles of construction and discuss the principles or canons of construction in the Justum Generis and Nocicia Sociis, or known by its associates, and the principle of contra proferentum. One particular point that the court emphasised was that for the purposes of the construction of the written policies of insurance, the applicable background or matrix of fact included the fact that policies and written contracts were to be construed against the relevant legal background. And the relevant legal background included the fact that existing case law and the fact that both case law and statute law developed over time. It follows that parties to an insurance policy are taken to have agreed that the policy of insurance will be interpreted in the light of the general law from time to time, so that where a relevant expression has been given a settled meaning by the courts, that expression will be construed in the same manner in the future. By far the largest section of the judgment covered coverage issues. And in addressing issues of coverage, the court identified 3 groups of policies depending on the nature of the insuring clause. The first category of policy were what we might call disease clause policies. Those were policies where there was an insuring clause in the form of an extension to the standard damage interruption cover, covering non-damage based business interruption. You're familiar, of course, with the standard policy wording in a policy of insurance, which generally requires damage for business interruption to be included. Well, in this category of policy, it would be an extension, extending business interruption coverage to causes other than damage. The second category of policy are hybrid clause policies. That is those where the insured peril of the insuring clause is defined by reference both to restrictions on the premises and to the occurrence or manifestation of a notifiable disease. And the third category of policy are policies where the insuring clause covers the prevention of access or similar provisions. So clauses that provide cover where there's been a prevention or hindrance of access to or use of the insured premises as a consequence of government or local authority action or restriction. I'm going to deal first of all with disease policies. The court proceeds to determine issues of cover by reference to specific policy wording of policies underwritten by Argenta, MS Amlin Underwriting, QB UK Limited, and RSA. As I say, typically such policies provide cover where there's interruption or interference of businesses caused by or following the occurrence of a notifiable disease on or within a given radius of a business premises, or the discovery of an organism likely to give rise to a notifiable disease. In order to advise your clients, it's always necessary to focus on the policy wording of the relevant policy. However, in terms of general principle, the court held broadly as follows. First, there is an occurrence of COVID-19 within a radius where at least one person is infected with the disease within that radius. It's not necessarily that person should have been diagnosed, but he must have suffered from the disease. The same is true if the wording refers to the existence of any notifiable disease within the applicable radius. Secondly, where cover depends on the manifestation of a notifiable disease, the insured has to prove the occurrence, like the presence of a person displaying symptoms or who, while being asymptomatic, has been diagnosed with the disease. The mere presence of a person who is asymptomatic and has not been diagnosed would not suffice to establish the manifestation of a disease. Third, the word following imports some causal but not mere temporal connection. Doesn't necessarily, however, require the establishment of proximate causation. Fourth, and this is important, the word vicinity for the purposes of an insured event, defined as business interruption or interference to the insured business as a result of a notifiable disease occurring within the vicinity of an insured location during the period of insurance, is wide enough to cover the entirety of England and Wales. Moreover, even if vicinity is more narrowly defined, the cover is not limited to BI consequential upon the COVID within that vicinity. I shall return to that in a moment. Fifth, the insured peril is to be defined as the composite peril of interruption or interference of a business during the indemnity period following or as a result of, resulting from, or in consequence of one of the defined occurrences, not just the occurrence within the vicinity. So there's a composite insured peril, and that's of importance when considering the necessary counterfactual, to which I shall come when analysing causation. Sixth, and this is equally important, where cover is provided following any occurrence of a notifiable disease within a given radius or a manifestation, cover is not confined to the local effects of that occurrence, but extends to the effects both within and outside the defined radius. Therefore, perhaps take an extreme example. If there were a single occurrence within 25 miles of the insured premises, but the business suffers loss by reason of a general lockdown, the business is entitled to an indemnity against the consequences of the lockdown or the public response to the disease, not merely the consequences of the manifestation or occurrence of the disease within the given radius. But it's important to note that the position is otherwise where the occurrence of the disease within the policy area is stated in the policy itself to be the insured event. In such a case, cover is only for the BI caused by the occurrence of the disease within the policy area. Finally, in relation to disease policies, in calculating the indemnity, reference should be made to the contractual quantification machinery, even where that's primarily applicable to damage-based perils, i.e. loss caused by damage. That machinery should be taken to apply to the quantification of indemnity for business interruption with such modification as may be required. Therefore, a trends clause couched in language designed to apply to a damage peril ought to apply. However, in construing any trends clause, one has to exclude from the relevant counterfactual any part of the insured peril. That is the loss due to the occurrence of COVID, both inside and outside of any given radius within the indemnity period. Such a clause therefore might have to be read as if it provided along the following lines. Adjustments shall be made as may be necessary to provide for the trend of the business and for variation in or other circumstances affecting the business either before or after the occurrence of the insured peril, or which would have affected the business had the insured peril not occurred, so that the figures thus adjusted shall represent, as nearly as may be reasonably practicable, the results which but for the insured peril would have been obtained during the relative period after the occurrence of the insured peril. The same is true of the application of the definition of standard turnover. In calculating standard or general turnover, one removes the effects of COVID both inside and outside the relevant location. Next, going to deal with hybrid policies. As I said before, these are policies that define the insured event as BI caused by an inability to use premises due to restrictions following an outbreak of a notifiable disease. The hybrid element being the requirement both to show restriction on the use of the premises and the existence of a disease. The court proceeded to determine issues of cover by reference to specific policy wording, this time of policies underwritten by Hiscox and RSA, but I shall attempt to again derive some generally applicable principles. First, restrictions imposed means something that is mandatory, not advisory. Either restriction must have the force of law. They must be imposed by a public authority, even if that is not expressly stated in the policy wording. The restrictions are therefore those promulgated by statutory instrument, and in particular, the regulation. Guidance and exhortation, even by the Prime Minister, don't suffice. Secondly, unable to use means something more than hindered in using. An insured might not be unable to use premises, even though he can't use all of them. However, it's important to note that partial use might be so nugatory as to amount to an inability to use the premises. Moreover, while the restrictions need not be directed specifically at the insured premises, the restriction on persons leaving their home, save a reasonable excuse, imposed by Regulation 6 of the regulation, will not, save in rare cases, suffice for an inability to use. Third, an occurrence of a disease would include a pandemic. Occurrence is not confined to a localized outbreak. Thus, the occurrence of COVID-19 in the United Kingdom suffices for to be an occurrence of a notifiable disease. Therefore, national restrictions imposed because of that outbreak followed the occurrence. Fourth, policies that require interruption rather than interruption or interference don't require complete cessation of business. Fifth, enforced closure of premises occurs if all or part of those premises are closed under legal compulsion. That is, closure which is or could be enforced legally. Where such enforced closure has to be for health reasons or concerns in or within a distance of the vicinity, the same wide meaning as I discussed in relation to disease policies will be applied. But even if a narrower meaning were given to it, the health reasons or concerns would apply to all vicinities. Sixth, the restrictions need not be due to the occurrence or manifestation of the disease within the defined geographical area. Provided there is the necessary occurrence or manifestation, cover is provided where restrictions are imposed by reason of a widespread outbreak of the disease. Seventh, as with the disease policies, the trends and counterfactual clauses which apply in respect of quantification will be taken to apply with such modifications as may be required, even though they may not refer to restrictions. Thus, the following wording might have to be added to the trends clauses to make sense of them, but will be so added. And the wording will be along the following lines. Or if you had not been unable to use the insured premises due to restrictions imposed by a public authority following an occurrence of any human infectious or contagious disease, an outbreak of which must be notified to the local authority. And finally, in applying the counterfactual, regard has to be had to the composite nature of the insured peril, which typically, in the case of hybrid policies, includes three elements. First of all, an inability to use the insured premises. Secondly, that must be due to restrictions imposed by a public authority. And finally, that must be following an occurrence or manifestation of the defined disease. Therefore, all three elements have to be removed in construing the applicable counterfactual. And I shall come back to that when considering causation. So the third type of policy considered were those policies which require the prevention of access or similar wording. These policies identify the insured peril to be the prevention or hindrance of access to or use of premises caused by government or local authority action or restriction. Court proceeded in this case to determine issues of cover by reference again to specific policy wording of policies underwritten by Arch Insurance, Ecclesiastical Insurance, Hiscox, MSA, RSA, and Zurich. In this section, the policy have quite different provisions, but I shall again attempt to identify some decisions of general application. First of all, prevention isn't the same as hindrance. Hindrance only requires proof of access being rendered particularly difficult. But where the peril includes prevention of access to the premises due to the actions of advice of a public authority, the insured must prove actual closure of the premises for the purposes of carrying on the business which was being undertaken prior to the public action or advice, consequential upon the action or advice. It doesn't, however, require it to become legally or physically impossible to access the premises. To take an example, a publican might be able to visit his pub for the purposes of maintenance, but access to his business would be prevented, or her business, if the pub had to close for business. Contrast is to be drawn between the pub or restaurant, which falls within category 1, which had a takeaway service prior to, and one which merely opened such a takeaway service following lockdown. In the latter case, that is the case where the pub or restaurant didn't have a takeaway service before lockdown, there is a fundamental change in the business sufficient to attract cover, as there is with the theatre or cinema, which falls in category 2. That starts remote performances during lockdown. But in the former case, there isn't. Likewise, Regulation 6 of the 26 March regulations don't prevent access. Category 3, that is essential shops, can still trade even though customers are required only to purchase essentials. However, category 4, that is non-essential shops, were required to close by Regulation 5 of the regulation. Therefore, access to them was prevented. Access to businesses not listed in the regulations, category 5 businesses, for example, our own businesses, construction and undertakings and manufacturers, was not prevented. Secondly, where the insured peril requires the occurrence of the occurrence of an incident, the insured has to prove the occurrence of an event. That is something that happens at a particular time, at a particular place, in a particular way. That is particularly the case if the incident is defined so that it has to occur within a specified distance of the insured premises. So for these purposes, a pandemic, and therefore COVID, will not be regarded as an incident. Third, as with the hybrid policies, where the peril is defined so that the restriction on access is imposed or ordered, there must be a mandatory restriction. Where the action has to be by a competent local civil or military authority, that extends to central government action. The meaning of action clause specific. It may extend to advice, where the action in question is only required to hinder access and use, but may not, where the action is required to prevent access because advice doesn't have the force of law. Fourth, also as per the hybrid policies, interruption in the insuring clauses will generally be construed so as to extend to disruption to or interference with the business. It's not confined to cessation. Thus, cover is provided to those businesses to which access is only permitted for a limited purpose. For example, the Category 1 pub or restaurant only permitted to sell food or drink for consumption away from the premises. But access isn't hindered in respect of Category 3 essential shops or Category 5 businesses not referred to in the regulations. And yet again, Regulation 6 doesn't hinder access, but it may hinder use. Fifth, where action has to be following a danger, disturbance, or emergency in the vicinity of the premises, that connotes a narrow, localized form of cover. For example, a bomb scare or gas leak causing a localized evacuation. It doesn't extend to a pandemic, such as COVID, justifying the imposition of national restrictions. So unlike in the case of the disease policies, vicinity in this context connotes the area surrounding the premises. Localized measures might, however, suffice for cover. The position to be contrasted is that which applies where it is the actions that have to be in the vicinity, where nationally applicable measures would suffice, because they are equally applicable in the vicinity. Sixth, in construing the trends provision, the comparison required for the assessment or adjustment of a BI loss is between performance of a business as a consequence of the insured peril, for example, prevention of access to the premises due to the action or advice of the government due to the emergency, and what the performance of a business would have been but for that emergency and consequential government action or advice. However, any loss suffered before the government action or advice due to the socio-economic consequences of a pandemic cannot be recovered. As I said at the outset, by far the largest section of the judgment was dealt and what addressed coverage. There was a short section towards the end on causation. Perhaps the reason for the relative shortness of this section was that coverage had very significant implications for causation. Nevertheless, the judgment did briefly address the issue again, causation. The key question is, what is the proximate cause of the loss? And the answer is the insured peril. Therefore, in determining what BI has been caused, the counterfactual one has to apply or posit is the business without the entirety of the insured peril occurring. So, working backwards, in the case, first of all, of prevention of access policies, typically, as I said, would be three interconnected elements in insured peril: prevention or hindrance of access to or use of premises, by action or advice of government, due to an emergency which could endanger human life. So the insured have to prove each one of those elements to establish cover. The counterfactual, therefore, requires stripping out all of those three elements, not just prevention or hindrance, and asking what would have happened if none of those elements had occurred. The same applies with hybrid policies, say that the insured peril typically comprises the following three elements. First of all, inability to use the insured premises. Secondly, due to restrictions imposed by a public authority. thirdly, following the occurrence of an infectious or contagious disease. So applying the counterfactual, each one of those three elements needs to be stripped out. Finally, disease policies, they ensure against the effects of COVID both inside and outside the relevant area, and therefore the effects of the disease, both inside and outside the area, have to be stripped out in the relevant counterfactual. The proximate cause of a business interruption is the notifiable disease, of which the individual outbreaks form indivisible parts. An alternatively less satisfactory analysis the court held was that each individual occurrence is an effective cause, so that they were all affected because of a consequential national response. The effect, however, is the same. In either event, the national response has to be stripped out when dealing or when analysing the relevant counterfactual. And finally, in a very short section of the judgment, the court considered the issue of the forms of evidence that might in principle satisfy the burden of proof on an insured to establish prevalence in a specific area. And it was common ground at this stage that specific evidence, NHS death data, ONS death data, and reported cases are in principle capable of demonstrating the presence of COVID. And other reliable statistical evidence might also be used. So by way of conclusion, I should add declarations and orders arising out of a judgment were made on the 2nd of October, but so far as I'm aware, they aren't published as yet. Following the judgment, the FCA has written to the Chief Executive Officer of BI Policy Insurers, setting out its expectations. And one point of note is that the FCA states as follows. We also note that the treatment of any forms of government support as income for tax purposes may well differ from how the support should be assessed under a BI policy. Tax considerations generally don't form any part of the calculation of losses for BI policies. We therefore don't consider the government's treatment of the small businesses, retail, hospitality and leisure or local authority discretionary grants for tax purposes as a proper basis for insurers treating those payments as turnover under the policies. Nor do we see that insurers can apply these amounts as savings against fixed business expenses. That's because the amounts received are not attributable to any particular business expense, and policyholders will have used the grants in any number of ways. As the FCA recognises, the judgment has brought a degree of clarity as to the proper treatment of business interruption claims, but it remains to be seen whether any, and if so, which parts of the judgment will be subject of an appeal. In terms of an appeal, I understand that the court has granted leapfrog certificates enabling the FCA and a number of insurers to apply directly to the Supreme Court for permission to appeal, but so far as I'm aware, no such applications has yet been made. If you're looking for updates to the position, regular updates can be found on the FCA's website, and it's got a dedicated page for COVID in BI insurance. For your notes, it's www.fca.org.uk/firms/business-interruption-insurance. So in terms of the winners and losers, excuse me, the insurers lost on many of the coverage and causation issues. However, the application of the trends clauses was a victory for them, which might explain why, notwithstanding what was regarded as a good day for the insureds, the share price of some of the largest insurers rose following the judgment. Well, thank you very much indeed for listening. I appreciate that very detailed talk, and if anyone would like a copy of my notes, please come out, email me directly or my clerk, Gary Young. I shall be delighted to provide a copy of them. I shall now hand over to my colleague, Aidan Reay, who will address professional negligence of insurance brokers in this context. Thank you all very much indeed.
Thank you and good morning, everyone. There are, I see some questions coming through. I will leave Andrew to think about the answers to that, and if we've got time, we will come back to them at the end. But thank you very much for your questions, and do put them in the box if you have some. I'm going to be speaking about claims against insurance brokers, which is one would think the next logical step in the chain following on from the success or failure of people's claims, again, on their insurance contracts. Hopefully, my slides have all come up now. The starting point for this talk is to think about what is the obvious starting point in any claim, which is what are the source or scope of the duties owed by a defendant. There are a number of different sources of brokers' duties, and the very first starting point is going to be the contract pursuant to which an insurer-broker acts. The contract will likely set out the duties that they had and the obligations, the scope of the service that they were to provide. In particular, it will likely set out whether the broker was undertaking an advisory role and whether or not the broker was supposed to be providing an opinion about the scope of the cover. The contract will also set out limitations on liability, although whether those limitations are enforceable is obviously another matter. One will obviously have to think about, for example, the scope of the Unfair Contract Terms Act, and one will also have to think about the scope of the obligations found within the FCA handbook as to whether or not certain limitations are going to be enforceable. The contract will also expressly and impliedly incorporate a duty to use reasonable care and skill. The second source of brokers' duties is the duty of care they owe in tort, and somewhat anomalously, whilst the law struggled for a long time to recognise concurrent duties in contract and tort until the 1990s in Lloyd's litigation, in the context of brokers' duties, the concurrent duty has been recognised for a long time. And so there are cases going back to the 1920s on the topic. The importance, I think, of a tortious claim is twofold. One, a tortious claim will have a slightly different limitation period, and in particular, there is the potential to benefit from the date of knowledge basis for limitation to start running. The second significant thing that a tortious claim raises as a possibility is the potential for the duty of care that's owed in tort to exceed that which arises in contract if, in the circumstances of the case, the broker exceeded his contractual obligations and assumed responsibility for advice which went beyond that which he was contracted to provide. The third source of brokers' duties is statute. So under the Financial Services and Markets Act, section 138D, subsection 2, a contravention by an authorised person of a rule made by the FCA is actionable at the suit of a private person who suffers loss as a result of the contravention, subject to the defences and other incidents applying to actions for breach of statutory duties. So this gives rise to a self-standing statutory right of action for breaches of FCA guidance. And in the context of insurance brokers, they are governed by the Insurance Code of Business Sourcebook, the ICOB as it's referred to. A particular relevance in that is ICOBS 5, which deals with identifying clients' needs and advising, and ICOBS 6, which deals with the provision of information. The content of the ICOBS sourcebook is important, not just, I think, because it gives rise to a self-standing right of action, potentially if it's been contravened, but also it helps you to flesh out the contents of the duty of care. Whilst the two will not perfectly overlap in all situations, by way of general guidance and as a good touchstone, the tortious duty of care is, I think, in most cases likely, but not inevitably going to, cover the requirements set out in the FCA handbook. And so where one is trying to think about what the specific duties might be in tort on an insurance broker, reference to the source book is a good place to go in order to flesh out a slightly nebulous concept. The final sort of duties, which is really simply included to name check it here, is equity. Brokers usually act as the agent for the insured. They can also act as the agent for the insurer as well in some situations, and that will give rise to fiduciary duties. However, in the context of claims brought against brokers as a result of their failure to arrange effective business interruption insurance to cover insured for the pandemic, I think it's unlikely that the equitable duties will themselves offer anything extra in those cases. When one is looking at broker's negligence, the obvious question that then arises once one has identified the duty of care, or even the duties under statute, is, well, what is the standard of care? And as far back as 1833, in Chapman and Walton, there was discussion about this, and Lord Tyndall, the Lord Chief Justice, considering what had been argued in that case, talked about the level of skill and care required. And in that case, he said, well, the defendant hasn't contracted for an extraordinary degree of skill, but only a reasonable and ordinary proportion of it. And so the court in that case thought it was satisfactory if a majority of skillful and experienced brokers would have come to the same conclusion as the defendant. And he said, well, if 9 brokers of experience out of 10 would have done the same as the defendant under the same circumstances, or even if as many out of a given number would have been of his opinion as against it, he who only stipulates to bring a reasonable degree of skill to the performance of his duty was entitled to a verdict in his favour. That effectively is a statement of the duty of care, which is one that or standard of care, which we would recognise today. The idea of looking at what the reasonable body of opinion in the area is. So how might liability arise in the context of the pandemic? Well, much like what Andrew said in the context of business interruption claims on your insurance, in each case, it's going to depend on the facts, and it will depend on why the insured was not in fact insured for the business interruption consequences of the pandemic. There are a number of possibilities. Did the broker fail to adequately assess the client's needs? Did the broker fail to effect insurance which met the client's requirements? Did the broker have a discretion that he failed to exercise reasonably? Did the broker fail to give advice on the terms of cover, or did he fail to give proper advice? In that regard, it's worth noting that there is a distinction between a duty of care case, where the broker has failed in some way in his duty, and a strict liability case. So if a broker is contracted to achieve a specific result, to incept a particular policy, and that is his obligation and fails to do it, that will give rise to a strict liability contractual breach of contract claim. That won't necessarily have to look at the court case of whether or not he behaved reasonably or not. It's simply a case of he was contracted to achieve X and he didn't achieve X. Most cases, however, are probably going to be unlikely to fall within that sort of claim, because most cases are going to involve the question of whether or not the insurance that was achieved, was incepted, but which didn't respond, whether or not in obtaining that insurance, in arranging that insurance, the broker acted with reasonable care and skill. Specifically in the context of the pandemic, there are a few points, I think, which are just worth noting in the background, because I think they will form the basis of I may be proved wrong, but I think they will form the basis of how a lot of people think about these cases, things that they start to think about when they're assessing what the broker did and whether it was good enough. Based on the FCA test case, it looks like there are going to be policies that will respond and ones which won't. But pandemics are not new. They've been on the National Risk Register since 2008. And when they went on the National Risk Register, they weren't considered to be an inconsequential risk. So this is a graph taken from the 2008 National Risk Register, which is available online. And what you will see on it is that the relatively likelihood of a pandemic, in this case specifically an influenza pandemic, but the relative likelihood of a pandemic was considered towards the higher end, or the more likely end, of the different things that were covered. So it was similar to severe weather, only slightly less likely than attacks on crowded places, and behind attacks on transport and electronic attacks as the most likely risks. It was ahead of non-conventional attacks, inland flooding, coastal flooding, or attacks on critical infrastructure. It was also considered more likely than animal disease, and many of you might well remember the impact of foot and mouth many years ago. The other thing that's interesting is not just its likelihood, but its relative impact. A pandemic is considered to have the most significant likely impact on the country ahead of any of the other risks. So on a likelihood and impact basis, it is coming out, when you blend them, it is, as you can see on the graph, coming out at the top. The risk register focuses, when one reads the detail, predominantly on the risk of influenza, but it does also note the emergence of SARS. And COVID-19 is not the first new disease to hit the headlines in the last 20 years. We've had MERS, bird flu, and swine flu. They've all appeared over the last 20 years, and they've all had, to a lesser or greater degree, economic impacts in areas where they have had significant outbreaks of those diseases. So the questions that one wants to be thinking about is, well, if you're in the business of risk management, should you have been giving a high level of priority to the potential disruption of a pandemic? And should brokers have been alert to the limitations on cover arising as a result of diseases? That's going to involve an analysis of a lot of different factors: cost, availability of policies. And these are all things that will have to be looked at in the course of the inevitable cases, I think, which will eventually come. If, however, non-responsive policies were widespread, one of the questions will obviously be, would a broker be negligent in recommending one of the policies that didn't cover the pandemic to his client, or not advising on the point, not advising on the limitations of the cover within the policy? Going back to Lord Tyndall's formulation, he seems to say, well, if 9 out of 10 brokers say they would not, then that suggests that it's not negligent. But I do think in this context, it's worth noting that it is open to the court in certain situations to reject the view of a profession if the court concludes that the view of that profession is not a reasonable one. So it may be that there is scope for arguing, if it transpires that brokers were regularly advising people, and most of them were advising people to take out policies which wouldn't cover pandemics, or simply not giving advice on the issue, it may still be open to the court to say, well, notwithstanding the fact that what you, the defendant broker, did appears to be within the scope of the body of reasonable professional opinion, the court finds that that professional opinion wasn't reasonable. Will the court arrive at such a conclusion? It's difficult to say, but there's certainly an argument to be made there, it would seem, because if you were covered for flooding or severe weather events, the question has to be asked, should you also not be covered for pandemics? If a claim against a broker succeeds in principle, the next question obviously becomes the one of, well, what is it worth? And the starting point for measuring damages is that a claimant is entitled to the difference between what they were paid by any insurance, if the insurance paid out at all, and what they would have been paid had the broker acted properly. One of the major limitations on the recovery of damages from broker's negligence is that if the policy that was required was more expensive than the policy that the client had, and the client wouldn't have taken out that policy because it was more expensive, then if that can be proved by the defence, the broker's negligence is not causative of the loss, because simply put, had the broker advised the client properly, they still wouldn't have taken out the necessary policy. What about further losses? Well, in Ramway Limited and W.J. Emerson and Co. Limited, the road traffic case back in 1987, the Court of Appeal held that consequential losses weren't recoverable. In that case, the plaintiff was seeking to recover hire charges for hiring a replacement lorry when his broker's negligence meant he wasn't insured. It was rejected on two bases, the first of which was that he couldn't recover because of his own impecuniosity. That's no longer good law. The second basis was that his losses were effectively damages on damages, that he was seeking damages as a result of the hirer not paying out, as a result of the broker rather not paying out sooner. Now, whilst that decision has subsequently been upheld in some contexts, in the Arbery Group and West Craven Insurance Services litigation, it was specifically held by the High Court that it didn't apply to business interruption insurance. The whole purpose, the court said, of business interruption insurance is to inject additional funds into a business as a going concern. And so, as a result, the failure for the business to be adequately insured is, well, it's reasonably foreseeable that the consequence of it is that there may be further losses. Of course, in the context of the pandemic, one of the questions may be, well, what profits would have been made? Because whilst the business interruption insurance will cover those things that it covers, if as a result of it you would still have been unable to continue trading into the future, and one of the things would be that we'll have to see how, for example, the second wave develops, it may be that the economic circumstances in which we find ourselves going forward are such that the point may quickly become moot. It'll be an interesting point to work out where the distinction is between those losses which would have been covered under the business interruption insurance and those losses which result from not having received a payout under the business interruption insurance. That will be a fine line, and that will have to be developed in the jurisprudence as things go forward, I think. So by way of summary of these points, I think the key thing to note is that businesses which are not covered by business interruption insurance are likely to be well advised to consider the potential of a claim against their broker, with the result that these claims are likely to start to appear soon. The critical thing in most cases will be, as it is in every case, the facts. What was the broker asked to do? What did the broker do? And what did the contract provide for? A key factor in liability is likely to be the view that the courts take eventually on the risk of a pandemic. Should this have been considered a real and significant risk prior to 2020? And does it make sense that a business interruption policy might respond to other risks, but not to a pandemic? Those questions are going to have to be answered within the context of evidence, which looks at the availability of policies, the scope and width of policies, and critically, the cost of policies, as well as expert evidence, I think, on what brokers generally were doing in the market. I think we've probably got time to have a look at a few questions, but as ever, can I just thank you for joining us this morning and remind you that you can follow King's Chambers on Twitter and LinkedIn, and that feedback forms will be sent out following the seminar, and we do appreciate all feedback that you can give us.
Well, thank you very much indeed, Aidan. I'd reiterate what he's just said. One thing I should say out on the subject of LinkedIn, when you're considering prevention of access and the hybrid policies, the court relied upon an analogy with force majeure clauses in terms of prevention and hindrance. And I posted onto my own LinkedIn site or entry a talk I gave in relation to force majeure, and that might be of some assistance to you. There's a few questions which I think are directed at me. The first question is from Mr. Robert K, and he asks two questions. What are your thoughts on whether COVID causes property damage, no alteration of state, etc.? Well, I can say this, that in the judgment, there was a concession that where the policy did not have an extension, so that the only business interruption cover was that available following or consequential upon property damage, there would be no cover. So I think the answer to the first question is that COVID does not cause damage. I have to say to you, I think it's a very good question, because certainly prior to this decision, there was speculation as to whether or not it might be arguable that COVID caused damage to a particular site if there was an outbreak at the insured premises. Second question is, might COVID come within the closed definition of disease by many insurers as it refers to SARS? And they could have limited it to SARS 2003. Policies under consideration by the court included reference to SARS, but they also included general references to notifiable disease. The view I take is that if the policies in question are limited to SARS but do not extend to generally notifiable diseases, I think you'll be doing very well to establish cover. The second question is from an anonymous attendee, and the question is, if a broker hasn't yet notified a policyholder's claim, either because the clients haven't come forward or because they have seen the stock response from insurers and decided not worth it, should they do so now? And will or could insurers rely upon claims conditions? I think the short answer to that is I see no harm whatsoever in notifying as soon as possible. If there is a policy condition requiring notification within as soon as practicable, etc., I think the insurers will probably succeed on that. Certainly I've been to the Court of Appeal on such claims conditions and they're generally upheld. And I think if you're only notifying now, unless there's a recent particular issue affecting the business in question that only justifies notification now, I think you'd be struggling. Chris Heitzman asks me, which way will the Supreme Court go? Well, the first point to make is it's far from certain there will be an appeal to the Supreme Court. And the reason why I say that is because the insurers are presently engaged in talks with the FCA as to the practical implications of the present judgment, and it's only if agreement cannot be reached that any even application for permission will be sought. That said, if this matter were to go to the Supreme Court, I think the most likely issue that might be overturned is the wide definition given to the word vicinity in the context of disease and hybrid policies, because that's really the basis upon which it was a bad day for the insurers. The definition of vicinity, maybe as a matter of common sense, you might think would be limited to a local geographical area around the insured premises, but the court said no, it can extend to the entirety of the UK. So I think that's an area where the Supreme Court might well overturn the decision of the High Court. John Enoch asks me two questions. Further to what we said about the FCA and local authority grants and similar, presumably there is no argument that furlough payments can be deducted from insurance payments as they were applied to save expenses. I think there's an argument they should be deducted. I think it's quite difficult to argue that you've suffered an increase in expenses or a downturn in turnover without taking into account the furlough payments which would not have been made but for the pandemic. And of course, it's right to say it's not the court that made the observations I referred to at the end of my talk. It was the FCA really exhorting insurance companies to almost, you might say, play fair. I think they may not, if I can put it that way. Second question, is there not an argument that if insurers are obliged to pay out for loss, ignoring the fact that insureds have already received payments from government, that infringes the indemnity principle of insurance and gives the insured a windfall? Well, it depends upon what payments have been made and what the policy in question says, but I can see the point in principle, yes. Aidan, I think there's two questions for you on the context of insurance brokers negligence. So if you want to deal with them, I'll
yes, I will. Sorry, David Harlock asks about section 138D, which, as he rightly points out, is limited to a claim by a private person. I think I was perhaps slightly unclear about what I was saying there. The key thing I think about the ICOBs is that they provide guidance about what sort of things a broker should be informing somebody of. Now, in the context of a sophisticated business operator, it may well be that those play a very little role in determining the scope of a liability. But in the context of claims by small businesses, I think there's certainly a good argument to be made that brokers have analogous duties in common law to provide similar sorts of information. The reality is that a couple who run a pub, whilst they're obviously legally in a different position when organising insurance for their pub to organising insurance for their home, I think a court would be sympathetic to the idea that they are not sophisticated operators and would require more information than a publicly listed company, incepting lots of policies each year with people doing things in detail. I have an anonymous attendee who says, when considering causation for brokers, can a policyholder without cover say they should have been placed with one of the policies on which the FCA succeeds, bearing in mind it was never insurer's intention to provide this cover and there is really only cover due to poor drafting? Can brokers argue that such a policy would not have been available but for what has ultimately occurred? I mean, that's a question ultimately, I think, about what comes out and what is finally resolved in the test cases. So whether or not there's a leapfrog appeal, and if there's not a leapfrog appeal, what is agreed between the FCA and the insurance companies about how policies are to apply. But ultimately, I think it would be difficult for a broker to specifically argue that, in fact, there were no policies that covered this, and it's just nobody meant, the insurers didn't mean to cover this, and so no policies that cover it, unless there is, in general, an acceptance in brokers' negligence litigation that when the broker is asked questions about the scope of cover, specific questions, he will usually refer those questions to the insurer and then simply act as a conduit to provide that information back. So does it cover X? He will ask the insurer about X and bring back the information. I suppose in the context of a broker who asked if insurance covers X, and X happened to be a pandemic or disease-related business interruption, and the response came back no, and it was subsequently found that that policy did in fact cover it and it hadn't been taken out as a result of that advice, I think the broker probably would be on stronger ground there, because he'd be able to say, well, I made inquiries, I asked the insurers what the cover was, and they gave me an answer, and I relied on it. So I think that in that specific situation, there would be more support for the broker in that case. I think that's all the questions dealt with. Andrew, I don't know if you have anything you'd like to add on any of those points.
Yeah, only one very short point, which is I think that the decision of the High Court in the test case may be a little bit surprising in the context of the definition of disability for disease. I'm not sure it's so surprising in the other aspects. BI, non-damage BI cover has always been available, even if it's only by a prevention of access clause. So I think the policies were there. I think one of the issues is that often an insured will say to its broker, please get me business interruption cover. Now, the broker may get that business interruption cover without pointing out the fact that it's a damage-based business interruption cover. So, of course, that won't help in the context of a pandemic, or probably won't cover a pandemic-caused BI. So I think that's one issue that you need to think about when considering the position of brokers. Well, thank you all very much indeed. If you do have any questions for either myself or for Aidan, please feel free to email us. If you want a copy of my notes, please do contact my clerk or email me directly. I'll be delighted to provide a copy. And thank you all very much indeed for attending. Bye-bye.
Goodbye.